Welcome to this Grand Rapids sitting of the Michigan Court of Appeals. As you just heard, our first case, we had a conflict in one of the cases, so Judge Redford was kind enough to substitute in. And so we're going to hear the first case, then we're going to take a 5-minute break, maybe 10 minutes, and then we'll come back on and Judge Maldonado will be with us. I also want to welcome Judge Ackerman to this fine city. There's a lot of repeat players here, so I'm not going to repeat kind of the normal admonitions, except for the fact that we have read your briefs. We've read research reports or bench memoranda that have been prepared. We've read the pertinent law, which is all to say that you don't need to repeat your brief. Please just get to the point, why you think you should prevail. And then if there's, what would be especially helpful is if anything's happened that we can be made aware of since you filed your brief. For example, another case came out, a statute was passed, although I'm not sure our legislature does that anymore. If you would provide that kind of information to us, that would be helpful. And then finally, if there's anyone who's been involved in a domestic abuse situation, or if there's any children who are involved in your case, please do not refer to their names, refer to them in some other way. So with that, I'm going to call the first case that we're going to hear today, docket number 372425, Crooked Lake Yacht Club versus Emmett County. I believe we may have someone appearing remotely. Is it Mr. Shortley?
No, Your Honor, Stephen Jopik.
Okay, please come on up.
Yes, Your Honors, may it please the court, Stephen Jopik appearing on behalf of Emmett County in this matter, the appellant. We have, as mentioned by Judge Schwartzel, we have thoroughly briefed the case, as has appellee. I don't want to repeat what is in those briefs, but I do want to identify just a few things very quickly. Certainly will not use my whole time, but we'll be happy to answer any questions you have. I'd ask to reserve 3 minutes in rebuttal if it's even necessary.
Okay.
In this case, unlike many other zoning board of appeals cases that are appealed to this court, the record is very thorough. The case was remanded by the circuit court back to the ZBA to make further findings. The ZBA did exactly that. The ZBA went to great pains to make extensive findings and conclusions, both individually as individual ZBA members as they sat as the ZBA after hearing.
So I don't understand. Yes. So, you know, I get, and we saw the written findings of the board, and that being the decision that we're looking at made sense to me. I don't know that I understand why we should consider individual statements made by individual board members. To me, that just seemed like a legislator who, spoke on a bill on the House floor. That is the kind of legislative history that, frankly, we ignore for the most part. Why should we consider individual statements versus, the written decision of the board as a collective?
Yes, very astute comment, Judge Schwartzel. I think you're referring to the Beck case, perhaps, versus Northfield Township.
Case, it's just that's what we don't look at legislative history. It's not particularly helpful.
Right. And this isn't a legislative body, I think is the first thing to mention in that regard. This is a quasi-judicial body where comments and input from the individual members form the decision of the body as a whole. In the Beck case,
That'd be almost like our deliberative, if our deliberative process were transcribed, which thank heavens they're not, on an appellate panel, or our notes, that would somehow provide authority when a court speaks through its orders. Why isn't the same thing true for the ZBA board?
but I don't think there's any case law that specifically says that. The Beck case decided by this court at the beginning of 2025, I think it was, Beck versus Northville Township, a published case. It does hone in on this very issue. And let me, if I may I read just part of that decision where the court touches upon this. It says, in that case, the court found that the ZBA did not make adequate findings and conclusions, and it recognized both the individual comments made by the individual members of the ZBA, or I'm sorry, in that case, it was a planning commission, their individual findings and conclusions, as well as the ultimate decision. It did, in fact, emphasize the ultimate decision, but it did also recognize the comments from the commissioners. The court said, none of its individual commissioners made findings or conclusions about whether or to what degree Beck's complied with the standards for a special land use in that case. And the Planning Commission never incorporated its members' individual concerns in a statement of findings or conclusions stating the basis for the denial. The and there, I think, is significant. The court recognized that both are important to the decision-making. I think both are relevant. And if you will, a motion made by a body such as this, which I think the court, with all due respect, they are a voluntary group of non-lawyers. And I think that's valid for the court to consider.
In the motion, in the ruling on the motion, you know, the written decision, in that decision, did it incorporate explicitly all of the comments made previously by the individual members as part of its analysis?
It did not, but I think it encapsulates and summarizes those just by the nature of the more broad statements made. It was a page and a half of conclusions and findings, and it was thorough, and it touched on each of the standards.
So let's assume for purposes of our conversation that we're not going to look at those individual comments, and that we're going to look instead at that page and a half. So under standard 1, and I think, if I recall correctly, standards 4 and 5 really aren't at play here.
Correct.
We're really focusing on 1, 2, and 3, correct?
That is correct, Your Honor.
Okay. So under standard 1, what was the practical difficulty that was self-created here, in your opinion?
A number of things. First, the tent. The tent. The tent is an additional structure. It's an accessory structure. It is not the building itself that was a non-conforming building. It's separate from the building. It's a temporary structure.
But the request for variance, I think it was a variance, wasn't for the tent, it was for the patio.
Understood.
All right, so let's focus on the patio rather than, there's a lot of ink spilt on this tent, and I don't know that that's particularly relevant here. Let's just focus on the patio that was already built. What is the practical difficulty with regard to that patio that had already been built?
The self-created difficulty here, I think, is what you're honing in on, is the 5.5 feet that exceeded into the waterfront setback. Was that self-created? Did they install that? And why did they install that? And to get to why they installed it, the justification for installing it gets to the self-created hardship. First of all, they installed it without getting permission, but that alone is not their justification. They indicate, I'm sorry.
So I'll be honest. That makes sense to me that you can't build something that violates a zoning ordinance and then come and say, I want a variance, and say that the practical difficulty is that I'd have to tear it down. That is a self-created practical difficulty. But what about the argument that I think they also make, which is we have to have a patio of this size. And to have the patio of this size, it has to be where it's at. And where it's at violates the ordinance only because the lake hasn't moved and the yacht club building that was there before the ordinance hasn't moved. And so in that sense, it's not self-created.
Respectfully, I would disagree. They say they need that size because of the existing temporary tent that they have put up for decades. They have put this tent up. They say it's of such a size that they need the patio to fill in the entire area underneath that tent. And that's why the focus here by the appellee has been on that tent, that they need that 5.5 feet to get the full size of the tent.
I guess my
And-
point is that's not self-created
Well,
because it might fail under standards 2 or 3. But I mean, they've identified something that was a practical difficulty, and it's not self-created because it only violates the ordinance because the ordinance was put in place after the lake was formed in whatever glacier, thousands of years ago, and the yacht club, which was built before the ordinance. So it's not self-created.
again, respectfully, the tent, they created the tent. They chose to add the tent to the equation here and then use that tent as the justification for that additional 5.5 feet. That's the argument we laid out in our briefs. That's the connection. I understand the courts has concerns in that regard, but the tent is one of the many items that are self-created here. If that were not put in, if that were not a temporary structure on a seasonal basis, then they wouldn't need the 5.5 feet. Their entire argument fails, and the tent can be removed. What's the basis for the additional 5.5 feet without the tent? It can be removed and never used again. They use that area under that tent for decades, and they use that area outside without a tent for decades before that. They created these additions, these additional accessory this additional temporary structure on the property themselves. The county did not put that tent in. The county did not cause this supposed need for the additional 5.5 feet. It's a want. It's not a need that meets the criteria for self-created hardship or any of the other standards, as the other 2 standards that are issued in this case for all the other reasons in our brief. But
The trial court believed that the board failed to identify whether the conformity with the regulations would be unnecessarily burdensome under standard 2. Where do we go in that 1.5 pages and find where the board addressed specifically whether it would be unnecessarily burdensome under standard 2?
well, I'm looking at let's see, I'm looking at Appendix B, page 198, which is where these motions are, 198, 199, in the record, the appendix that we've supplied. Standard 2 is listed by the ZBA. There's a full paragraph there of their findings. They do refer to the growth of the club. Their finding is the growth of the club or an increase in size of events or participations is not given justification for granting a dimensional variance. As stated by the appellant, in this instance, the appellant was the yacht club, this area has been used for a number of years, and the absence of the patio did not preclude the owner from using the property or produce a burden great enough to prevent the use of the property. Therefore, standard 2 is not met. So they do refer to the burden, an unreasonable, burdensome. They found that it was not unreasonably burdensome. Additionally, as mentioned earlier, a number of the commissioners outlined a lot more detail in their individual findings that collectively show where the ZBA was at with this. Again, going back to a lay group of 5 members who are not lawyers.
But here it talks about a burden great enough to prevent the use of the property. But how is that unnecessarily burdensome?
But read in context, the fact that they did not use that area for decades prior to, and they find this a number of years, they never needed it. So why is it suddenly burdensome for them to not have it? That's what the ZBA is saying here. They didn't have it for decades beforehand. Why all of a sudden is it burdensome?
Wasn't part of their point that the use of the property was just increasing? They just had greater demand by members for the youth yacht club and other things. And so if you want to use the building and you want to use the lake, the need became greater, and it wasn't some nefarious reason or nefarious plan by the yacht club. It's just more people were interested in boating.
No, nobody's saying anything nefarious happened here in terms of it's great that they have more demand perhaps, and that's what they do talk about, that the club that they created there for sailing instruction was increasing. They wanted to expand it. Put that in the context, however, of the fact that this is a law that they're asking to get a variance from, permission to break the law, permission to do something that is against the law, heavy burden, right? If the standard were that, well, we have an increased market demanding that our bar restaurant have a patio that goes all the way, into the setback, you'll have variances everywhere if this court were to find, with all due respect, again, if this court were to find that just a market demand created the basis for a burden for purposes of granting a variance, the impact on the effectiveness and enforceability of zoning ordinances would be tremendous, and we would see a large influx of variance requests, I would imagine.
And then my final question, I think, is standard 3. What does substantial justice mean?
The court obviously knows what justice is better than most of us, maybe all of us.
What does substantial justice mean within the zoning world?
I think what it means in my view is that it really is focusing on the amount of the variance. We talked about size of the variance. Is it the minimum amount to do substantial justice to the applicant in the surrounding area? And implicit in that is the basis for zoning itself and the zoning law. The fact that it's a law, have to take into consideration that this is a law, again, that applicants seek to achieve variances to allow them to break that law. And to do substantial justice in light of the size of the variance is what the focus is on. It again gets back to the self-created difficulty, the burden on the applicant, as well as the impact on the spirit and intent of the ordinance. The whole prelude to these standards is following the spirit and intent of the zoning ordinance itself. And that says take into consideration when looking at this element, whether justice is being done to the community as a whole. These are waterfront setbacks, important for a number of reasons that involve protecting the waterfront, the aesthetics of the area, view lines, and among other property owners. And what can be done on waterfront properties. It's an area, as this court knows, is substantially litigated by property owners between themselves. It's very important, their view lines, and also the environment and protecting the environment, and things of that nature. So there is a lot that goes into substantial justice. It can mean a number of things here. Yes.
Anything else?
Truthfully, your question has actually touched on everything that I wanted to cover and enable me to talk about them. So if there is anything else the court would like to get into, I just rest with our briefs. I think it covers everything as thoroughly as we could possibly do, and went through each item very carefully. So I appreciate your time, and be happy to respond to anything in rebuttal if you
You'll have
need.
time for rebuttal.
Thank you.
Thank you. Mr. Is it Scholl?
That's correct, Your Honor. May it please the court, Judge Schwartzel and distinguished panelists, my name is Stefan Scholl. I represent the Crooked Lake Yacht Club, the appellee in this matter. And I will just say, I have a long prepared remarks.
I
But
don't
let
know
me
that
just
we
say,
need that.
Judge Schwartzel,
You're not making them very attractive to hear if they're long. Why
Judge
don't
Schwartzel,
why don't
let
you,
me just say,
Mr. Scholl, hold on. Why don't you focus on the tent? Because I think, that is something that opposing counsel stressed, and I think it's a good point. And why don't you explain why, the need for the patio to be of roughly the same size as the tent, why is that not something that is a self-created problem? And also, it would be, not unnecessarily burdensome just to use the tent rather than the patio. So why don't you address that tent issue?
I would be happy to address the tent issue. Um, Before doing so, if I can just preliminarily state, based on your comments and your questions, I just want to state for the court the obvious. The reason I became a lawyer, and the reason I believe you are all lawyers, and the reason the Michigan Court of Appeals and all of our courts exist is to ensure substantial justice for all citizens in this state. And I thank God every day I'm a lawyer that I'm able to do what I do. And I think, Judge Schwartzel, you have just honed right in on the absolute fundamental question in this case, which I believe the circuit court is required to assess. Was justice done? And I think the answer in this case is a resounding no. Now, when you talk about the tent, when we talk about everything in this case, I think Judge Deegan was correct. When you look at this record, when you look at Emmett County's brief, the ZBA was absolutely and positively obsessed with the fact that the patio was installed in the setback without permission,
Well,
first
I mean,
having been obtained.
I don't know that the ZBA was wrong to be concerned about something that's built that's in violation of an ordinance, but I mean, set aside, motivations or anything, just, you had a tent. The tent certainly went over the line, but it's a tent, it's temporary, so it doesn't violate the ordinance itself. Then your client builds a patio basically on the same footprint of that tent, but the patio does violate the ordinance. And so why is that practical difficulty not self-created by your client?
I will tell you, Your Honor, um, I believe the correct standard, again, for interpreting the self-created hardship was for the ZBA to consider the request as if the patio had not been built. And Judge Deegan stated that if that had been done, the standard should have been met. Because, as you've stated, the yacht club is non-conforming in all aspects. Currently, in order to build a yacht club in Emmett County, you need 600 feet width. This lot is 100 feet in width. The current waterfront setback for a building is 60 feet. And my client's building uh, barely meets that, actually had to obtain a variance to install a roof on an addition, which it recently built, because that went into the setback. So what you're dealing with in this property is a non-conforming structure, which is not even within the waterfront setback itself. And the evidence in this case shows that there has been a tent in the very small front yard of my client's property for decades. This building was constructed in the 1950s, way before zoning, and the tent has been there for decades and decades. Now, within the last 10 to 15 years, so that the tent would not blow away, anchors were installed, numerous anchors, I believe 48 concrete anchors buried in the ground to hold down the tent.
Mr. Scholl, Mr.
But
Scholl, Mr.
yes,
Scholl, why do you need a patio that is of the same dimensions as the tent?
because the rainwater comes off the tent when there are flooding rains, and this tent was specifically designed to further the intent of the ordinance. When you look at the waterfront setback ordinance provision, the ordinance specifically sets forth the intent of that provision, which is, and I will read 22.11(1)(a), avoid excessive structural encroachment of the natural waters and waterways, except for uses traditionally depending upon direct water access, such as the yacht club, where the sailors go right into the water in the dock right in front of the club. And I'll also say, with regard to structural encroachment, in this case, the record shows there is a massive concrete and sheet pile steel sheet pile wall together with stone riprap extending 5 to 8 feet offshore in front of my client's property. So does it further the intent, the patio? And I would say yes, under paragraph B, the intent of the waterfront setback is to promote high water quality. Okay. And this is for the purpose of trapping sediment and nutrients from entering natural waters. What we had in this case, the evidence showed, was there would be flooding rains, the water coming off the tent into the grass in the front yard, and it would create a mucky, muddy mess, rendering the front yard basically unusable. This water, there was an engineered permeable patio.
Mr. Scholl, it's, this is the problem of having remote oral argument, is that we talk over each other. So just try to watch when I start, or one of us starts asking questions, so you
I
can
apologize, Your Honor.
pause. Why wouldn't the answer that I assume the ZBA would suggest to you is to get a smaller tent? Why isn't that an appropriate response? Get a tent that would fit a patio that would conform to the ordinance.
Well, again, Your Honor, the court found that this tent and the concrete supports for the tent had been in place for well over a decade and were necessary to support the yacht club's programs and the use of its property. Now, I find the idea that
why can't your client make a platform that is smaller than the tent? If it goes in 5 feet, why not just make it 5 feet shorter? And then if you have 5 feet of covered grass and you got the rest of your the rest of your platform is complying with the setback provisions. Why couldn't you do that?
Your Honor, I believe the standard in the ordinance incorporate reasonableness and substantial justice. And
so the answer is they could have done it, but chose not to. Correct?
Well, the answer is that this patio is specifically designed to trap the runoff coming from the edges of the tent.
So what? So why couldn't you just make it 5 feet smaller and it's still going to trap all the waters?
Because then it would not be able to accommodate the programs of the yacht club in underneath the tent.
Do you agree your clients could have done that had they chosen to do so?
I believe.
Yes or no? Yes or no?
Yes, but I believe it would have no purpose and would be unreasonably burdensome on my client to to not grant the requested variance under the circumstances. And that has a lot to do with the fact that my client's property is fully non-conforming. It also, and I will say this, the one thing, in addition to the sheet pile and the fact that this is an extremely unique configuration of this lot, there is also a sidewalk which is in the front yard. And also, I think it's very important, which the court took into consideration. Under the ordinance, my client is permitted to install a 6-foot wide by 25-foot concrete sidewalk to the water, which would give you 150 square feet of permeable surface. And that would only aggravate the situation. It wouldn't help drainage. It would actually cause more water to run off into the lake and completely be contrary to the intent of the ordinance. However, this patio, which is designed to entrap the water and is engineered to protect the environment, would only occupy 165 square feet of area within the setback. So we're talking about a tiny, for all intents and purposes, a tiny change.
Mr. Scholl, as I recall from the record, I want to be careful and not say all, but it does seem as if the vast majority of neighbors were perfectly fine with your client's patio, correct?
There was not a single complaint from any neighbors. The neighbors enthusiastically support the patio.
Mr. Scholl, there's no suggestion that the patio somehow harms the environment. In fact, I think you could argue that it helps the environment by improving drainage, correct?
Absolutely, Your Honor. And I know the court questioned the inclusion of quotes from ZBA members in the briefs. If you read those quotes, they all state that everyone loves the patio and everyone recognized that it's very functional and practical. And yet again, they come back to this fixation on the ordinance standard. It's as if they are consider themselves unable to ever render a variance from the strict requirements of the ordinance, which is not what the ordinance states. And Mr. Jopich in his brief states that it's an extremely heavy burden to break the law. And you know what? The ordinance standards are there. My client satisfied those standards conclusively, in my opinion. And I believe that the ZBA's failure to properly apply and completely ignore the relevant standards is not permissible. And I think Judge Deegan's very well-reasoned opinion, after listening to hours and hours of arguments and reviewing hundreds and hundreds of pages in the record, is extremely thoughtful and well-reasoned. And I argue it would be very difficult for a court to look at her decision and find that it is clearly erroneous, and for you to have a firm conviction that she has erred. I think she did a fantastic job in this case. And again, we have to look at justice, and we have to look at the ordinance standards, and the ordinance mandates.
Mr. Scholl, we're repeating ourselves. We understand all that, and we will do that. Is there anything you want to add before we wrap this up?
I will, there's a couple issues here that I think are important.
Are they in your brief?
No. Emmett County claims that my client is trying to defeat the intent of the county zoning ordinance, and they cite National Boat Land. National Boat Land required screening, trees, and a wall to screen properties. And they're
I'm not
claiming
sure
that, oh,
what-
there's a precedent. If you grant the variance to CLYC, this is going to be detrimental to the community and defeat the purpose of the ordinance.
Mr.
Granting-
Mr. Scholl, we're just going to look at the ordinance and apply the ordinance as written. We're not looking beyond that. We're not looking at some, what's going to happen to this fine county over the next 50 years. We're going to look at the language of the ordinance. We're going to look at the language of the ZBA's decision and apply it. That's it.
I appreciate that, Your Honor. And let me make one other point, that they decided as they did. And basically, they were absolutely obsessed also. And one of their reasons is they didn't want to set a precedent by granting an after the fact variance. And I do not think that is appropriate, Your Honor. The ZBA, they stated repeatedly, we're not considering your application on the merits. The issue is you installed your patio in the setback. They completely ignored the ordinance standards and the evidence presented.
Okay. All right. Any other questions? Thank you. I'm sorry, Jopich? Jopik, you have a few minutes for a rebuttal.
Thank you. I don't even think I'll take a few minutes. I just wanted to point out, Your Honors, that as indicated by appellee, the patio is needed of the same size due to the rain. As mentioned earlier, just to reiterate, the rain was not a problem for the decades that the tent was in use.
Well, but there is evidence in the record that there was problems with runoff. There was problems with, the water going onto the grass and running down. I mean, is there anything to suggest that this patio is not an improvement in terms of drainage? Is there anything in the record to suggest that this is not a better solution for drainage?
The tent itself is a
That was not my question.
okay. Yes.
Is there anything in the record to suggest that this patio is not a better solution for drainage than just the tent?
Just the fact that the area is grassed and there's grass all around it, and everybody, it's
Wasn't
knowledge
there evidence that this actually improves drainage?
I don't know that there was no expert indicating that I recall in the record that it improves drainage. Again, maybe
Is it
general.
also fair to say that no neighbor complained about the patio?
With due respect, there was no neighbor that showed up at the meetings to go against the many people that showed up regarding this matter. There was a neighbor 5 doors down that was denied an 8-foot waterfront setback who did not appear, but I would imagine that individual would be somewhat upset if this were
That's
granted.
not in the record. I mean,
Well-
I asked a simple question. Is there anything in the record to suggest a neighbor complained about this patio?
No, Your Honor.
All right.
So, and just to finish on that, because I think it's important to emphasize that the neighbors and others, that's not part of the standards for granting a variance. And the ZBA has a very difficult job. Oftentimes, they have individuals appearing before them with some support and need to make a difficult decision. And likewise, they have people that appear at these hearings and disagree with the decision that they made. They make difficult decisions. So to require them to succumb to pressure from people showing up at their meetings is not one of the requirements for a variance.
Is it of any relevance?
I'm sorry?
Is it of any relevance?
I don't believe any case has found that neighborhood pressure to grant or deny a variance is relevant to a decision made by the ZBA. I'd also like to mention that rain is only during specific periods of time during the season. This is a permanent installation that will remain even if the tent is removed and smaller size, indicating that it will not accommodate the program. Again, this gets back to self-created hardship. The sailing program was created not by the county, not by the township, but it was created by the property owner, creating their own need for the for allegedly for the larger size patio, which again is questionable in and of itself. But if that's the basis, the program, again, we get back to that self-created difficulty that exists here. Lastly, to indicate that it's a tiny change in the setback is not quite accurate. It is a 20% plus change. The setback is 25 feet. This is a 5.5 foot variance into that setback. That's 20%. That's not tiny. That's more significant than inconsequential or tiny.
We understand that.
Thank you very much.
Thank you. That case is submitted. We'll take a brief recess. All right. We welcome Judge Maldonado, this fine panel. All right, we're going to call what is listed first on our docket. Docket number 370217, People v. Richardson.
Good morning, Your Honors. May it
Morning.
please the court. So while Mr. Richardson is not present in the courtroom today, he has been very proactive in advocating for himself throughout the trial court, as you can see in reference in the brief, and throughout my time representing him on appeal. So he remains actively engaged and interested in the outcome of this case. First, I want to start where this case started, just to highlight very quickly that Mr. Richardson was called to the scene where the mother of some of his children was
We understand how it got.
just if
how
you
it
could,
came
if the
about.
court would just indulge me just to highlight it quickly at the beginning, 2 sentences, just to remind the court that he didn't say, no, this isn't my problem. This isn't my child. It's my child's stepchild. I'll be right there. I'm here to help. And he also wonders, Mr. Richardson has since the beginning, if his name would have been run through lean without any articulable suspicion that he was up to anything at all, if it wasn't for how he looked. Mr. Richardson is a young Black man, and that's what started this all. He came to help, he was treated with suspicion, and that's what started this off. So just briefly, I'd like the court to keep that in mind. Now, once we get past all that to the trial itself and to the 4 issues I've highlighted, thank you for your indulgence in pointing that out. I know I said it in my brief, but I just wanted to highlight it. Just have a few things I'd like to highlight about each of the issues in our brief. The first one is that the issue of the attorney asking for a motion for directed verdict. If the attorneys, it's clear from the record that the attorney's the defense attorney's one and only trial theory was that the prosecution couldn't prove their case. So it's inexcusable to not ask for a motion for a directed verdict. Why leave it to the judgment of a jury who can come down either way, can follow the law or not follow the law, if your position is that the prosecution, by not providing a copy of the warrant, not proving that there was a warrant, could not prove their case. That's all on that. On issue 2, the guidelines being 18 months or less warranted just a term of probation for Mr. Richardson. Now, one of the things that Appellee's brief pointed out was that the court did say, you struggled with the officers for several minutes. But what is not pointed out is it's not even clear if the judge understood or was aware of MCL 769.344A. It is relatively new, and nothing was put on the record by the court to indicate, well, I understand that the law indicates that I shall impose a term of probation under these circumstances. But however, for the following reasons, I'm going to give you 45 days in jail. Also, this law comes into place if the top of the guidelines are under 18 months. Mr. Richardson was only 6 months, so a third of that. Issue 3, in this issue, appellee cites unpublished case law that possibly the fact that MIDC provides funding for indigent defense, pays the attorneys, that possibly the courts are still able to impose attorney fees that doesn't pass. I don't understand that logically. If the attorneys are being paid from MIDC, I don't understand how an attorney fee can be assessed by the court on top of that.
Well, wasn't your client told on numerous occasions, because this issue came up repeatedly. I think the trial judge suggested that your client have an attorney, and there was some questions whether to have one or not. But wasn't your client told on numerous occasions that there would be a court-appointed attorney provided if he was unable to afford one? I know that there was once when the trial judge didn't say that latter part about if he's unable to afford one, but wasn't it made clear that, his ability to pay would be considered at some point?
I don't recall specifically all of that, but one thing I noted that wasn't even addressed in Appellee's response was that the court actually said, now remember, Mr. Richardson, one will be appointed at you, quote, at no charge to you. So even if we get past the MIDC issue, which my client, of course, probably had no idea about MIDC and funding and all that, what about a direct representation from the court to my client face to face at no charge for you?
If you are unable to pay for one. And that, my point is that prior to that, the trial judge made that same point, but then added the proviso if you're unable to afford one. And once the trial, on one occasion, the trial judge didn't add that proviso. And my question is does that one instance invalidate all the other instances where the trial judge properly explained the circumstance?
Well, I'm not sure that there was really a hearing to inquire into his ability to pay at the time of assessment anyways.
There still hasn't been, has there?
Correct.
I mean, but if I remember right, the court hasn't come after him for those fees yet, correct?
I am not sure. I know he was ordered, I believe, 24 months probation. So I'm not sure if probation's terminated yet, but a lot of times it's not until costs and fees are paid. So I can check with him.
Okay.
And then the fourth issue, the issue of ineffectiveness of not appointing Mr. Richardson a new attorney. He indicated to the court a few things that I think were red flags that warranted an adjournment and his ability to either try to retain an attorney or to get substitute counsel or possibly to represent himself. First, he indicated that he only met with his attorney at pretrial the day he was appointed. He further indicated that the day before a jury trial, he only met with his attorney at 3 p.m. the day before the trial. And then the most important point that I think illustrates why this should have been granted is Mr. Richardson gave a very specific example that he wanted the video suppressed from this. It doesn't say in his request for a new attorney which video, but we know that there is a video that the woman in the back of the police car took. And I think if we have to talk about prejudice from not having that motion, I think we can, because whether or not that video would have been suppressed altogether is questionable. But I think there's certainly some areas that deserve to be redacted, the comments made by the person taking the video. But this is a structural issue, so we don't even have to prove prejudice here. He didn't have a good relationship with his attorney. His attorney opened it up by saying, we have an issue with communication here. And I think Mr. Richardson pointed out 3 very good points of why he should have been granted an adjournment and new counsel. So if the court has any questions for me, that's all I have.
Okay, thank you. You'll have time for brief rebuttal.
All right, thank you.
Good morning, Your Honors. John Donaldson on behalf of Ottawa County.
Morning.
I'll go in order as it relates to the first argument. I'll rely heavily on my brief, as I pointed out in my brief, that I don't believe that there's any ineffective assistance here because the motion for directed verdict wouldn't have failed anyway. And as I cited at the end of my brief, counsel is not ineffective for failing to present a argument that wouldn't be meritorious as it relates to the cases I've cited. Officers can rely on lien for their basis for effectuating an arrest. So I'll leave that argument to my brief. As it relates to argument 2, I indicated in there the highlights that the judge used when sentencing him to the 45 days in jail. She mentioned how he was obstructing for a significant amount of time. On top of that, how he resisted and opposed 2 different officers, even though he was convicted of the one and that he could have faced more charges. So that was another consideration she took into account. Counsel hasn't provided anything saying that the judge has to acknowledge that she knows the law or the standards, but the judge here did give reasons why she gave that jail sentence that I think would be applicable. As it relates to the argument 3 with the attorney fees, not only did I cite the unpublished case stating that the MIDC standards, there's nothing establishing that they apply to circuit courts, but on top of it, I also cited a case that indicates that People v. Jackson, that this ability to pay assessments moot at this point anyway, because that's not even brought up until the defendant is asked to actually pay. And there's nothing on this record that he's been asked to pay and couldn't pay. So I believe this hearing is premature at that point, that argument. And as it relates to denying defendant's motion for a new attorney, the court in its ruling of that motion, counsel wanted to argue the merits of this motion to suppress the video. As I pointed out in my brief, the court did say while during that argument for the new trial that she thinks that the video is admissible evidence. So the court tipped its hand and said that this is admissible evidence. So again, failure to file a brief that wouldn't be meritorious would not be grounds for ineffective assistance of counsel. I have nothing more to add. I'd rely on my brief if the court has any questions.
Thank you.
Thank you.
Just on the issue of the MIDC funding and the attorney fees, I think we need a published case that explains this for us. And I think we need a published case that says that when the court's being funded by MIDC and by this scheme that also having the court assess its own attorney fees, that I'm not sure that is going to the attorneys or not, needs to be addressed. And also, it's fine when I'm thinking about Mr. Richardson down the road. I don't know how far down the road he might get a warrant or a bench warrant to come on in and call for these $250 in fees. But I don't think that he's going to be appointed appellate counsel at that time to review that order. I just don't think it is, because I've been doing this for a decade and I've never come across a case where I'm appointed to review the imposition of a fine at some later date. So I would ask the court to address that now.
Okay,
Thank you.
thank you. That case is submitted. Calling the second matter on our docket, docket number 368940, People v. Wilson. I believe we have someone remote and we have Mr. Donaldson. Is it McCaskick?
Yes, Your Honor.
All right, you may proceed.
Thank you. And good morning to the panel, and may it please the court. Ryan Machasik on behalf of Mr. Wilson. There are just a couple of things that I would like to emphasize in the arguments without rehashing all of it. And that is primarily on the issue of suppression. The controlling authority here is the Gant or Keimel as reaffirmed by Gant. The prosecutor cites to Robinson, a 1973 U.S. Supreme Court case, and Chapman, a 1986 Michigan Supreme Court case. At least as to Robinson, I would point out that at page 5 of the prosecutor's brief, the portion cited relies, at least in part, on Harris. Harris was actually overruled by Keimel. And that overruling was recognized in Keimel by the dissent at page 771 of that opinion. So here, the controlling authority is going to be the rule set forth in Keimel and Gant. And that is that if there is no possibility that an arrestee could reach into the area that law enforcement officers seek to search, both justifications for the search incident to arrest exception are absent and the rule does not apply. Those justifications or reasons being officer safety and preservation of evidence for the crime of arrest. Here, Mr. Wilson was arrested on an outstanding warrant. He was handcuffed, secured, and placed in the back of a caged police cruiser. Only then did the officer begin the search under the bright line rule set forth, under Keimel and Gant, there was no rationale. So the justification for the search incident to arrest doesn't apply. This was not a valid search incident to arrest.
What about inevitable discovery during an inventory search when they get back to the police station?
Your Honor, that was not argued below. It was not argued here. And there's no record of what the inventory search policy is for the arresting agency.
Okay.
I would then move over, if there are no questions on the suppression issue, to the privilege and IAC waiver.
Please.
Thank you, Your Honor. And on that, I'm not going to rehash how important the privilege is between a defense lawyer and his client. We discuss any number of things related to motions, related to sentencing, related to mitigation, related to what may have happened in a case. To allow a wholesale kind of rifling through those communications, anytime an ineffective assistance of counsel claim is brought forward, goes well beyond what is necessary. What we're asking the court to do is to make a determination that while there is a waiver, that waiver is limited in scope, and it is limited in scope to those communications from the defendant to his lawyer that affected the lawyer's decision, in this case, to bring or not bring a particular motion. I can imagine a situation in which a client tells the lawyer, "Look, just go get me a deal. Don't file any motions. Just go, try and get me a deal." In that case, if it's later, if there are no deals and no motions brought and a deadline is passed, I think validly that lawyer could come forward and say, "Yes, I did not bring it because the client told me not to bring them to pursue this alternative path." Here, as was proffered to the trial judge, the lawyer, we believe, would indicate that there was no communication from the client that affected his decision to not bring a suppression motion. Under those circumstances, I think that should be the end of the inquiry. And I think it's kind of analogous to the way that when we're talking about Brady disclosures, the prosecutor can place a representation on the record that we've gone through everything, and there's no additional Brady material, and that ends the inquiry. We rely on the prosecutor's representation that they have done this and that there is no further Brady material. I think that same thing should apply when a defense lawyer stands up and says, "My failure to do something, so my ineffectiveness was not affected by anything the client told me." I don't think it is then appropriate, and it doesn't serve the purposes of the privilege to allow a prosecuting attorney to then rifle through any other communications between the defense lawyer and his client. It is probably one of the most important privileges. It is what allows us to represent our clients with the full faith that they are going to be able to trust in our guidance, and that they can inform us of everything relevant to their case. And unless those communications affect the decision, they should not be subject to further inquiry in court. With that, I will rest for the remainder of my briefs, but I'm happy to field any questions.
Okay, you'll have time for rebuttal.
Thank you, Your Honor.
Thank you. Mr. Donaldson?
Defendant appellant's brief relies,
Putting your name on the record.
oh, sorry, yeah, John Donaldson, representing Ottawa County. Defendant appellant's brief, again, relies heavily on Arizona Gant, which doesn't apply to this case. I went back and again, right before we go on the record, Arizona v. Gant, that relates specifically to limiting the search incident to arrest. It doesn't make it unjustifiable. And if you read Arizona Gant front to back, it relates to search of compartments of a vehicle as it relates to searches incident to arrest. And it justifies that when people are arrested, there's no reason for officers to go back and look at the car they were just in, that it's remote. That's not the case we have here at all. This defendant, the drugs in the tin that were found were on his person when he was arrested. We're not talking about a search of a vehicle as laid out in Gant. Gant is not applicable to this case.
Good analogy.
Thank you. As it relates to the second argument, as it relates to waiver of attorney-client privilege, as I stated in the Mitchell case, 454 Michigan 145, by putting an issue of effectiveness of representation, defendant received at the trial, he waived the attorney-client privilege. Our Michigan Supreme Court seems to indicate just making that an issue is a waiver of the privilege. I know the argument is that they want to limit it in scope, but that could lead to potential useful or relevant information being hidden behind this limited waiver of the information. For example, in this case, if the defendant, if we're asking about, well, why didn't you file this motion? And that's the limited part of the waiver. What if he didn't file the motion because it was a trial strategy, or it was because he wanted to go for a plea, or all these other areas of topics that wouldn't be part of the waiver? Relevant evidence as it relates to whether or not the counsel was ineffective would not be gathered in any of these hearings. As it relates to, the court can limit the questions. Well, if we have a hearing on ineffective assistance, and the prosecutor starts asking questions, as counsel says, just to kind of pry into their relationship, the court during the hearing can say that those questions aren't relevant. There's still safeguards. It doesn't mean that we can start digging into every single issue brought up between their relationship, but the fact that they can try to limit what their waiver is in violation of what the Michigan Supreme Court ruled in Mitchell. And I have no other arguments unless the court has questions.
No, I'm good. Thank you.
Thank you. Mr. Makazik? I'm sorry, I've destroyed your last name. I apologize for that.
It's quite all right. It's Machazik. It oddly is just as it looks.
Yeah. I tell
Thank you,
people
Your
that
Honor.
was forceful.
I will be-
They never believe me. Go ahead, and you have time for a brief rebuttal.
Thank you. I'll be very brief. One, Gant is applicable, right? Gant is the case from 2009, and it reaffirms Keimel from 1969. And so that is really the value of Gant. Gant, I admit, was an automobile search case, but it is a search incident to arrest case. And that's what we have here. So simply the fact that Gant was involved in automobile does not mean that it is inapplicable, right? The court analyzed, including reaffirming Keimel, the search incident to arrest, which is the claim here. And so I think Gant, and at least its analysis, does apply, recognizing, of course, that we're not dealing with a motor vehicle. As to the privilege claim, I'm always hesitant to even partially agree with the prosecuting attorney, but there is some extent to which I think we do agree, and that is if it's a matter of trial strategy, right? So if the trial attorney stands up and says, "This, I did not file it as a matter of trial strategy." One, I don't know how failure to file a pretrial motion could be trial strategy, but that does not involve the attorney's decision as a matter of trial strategy. Does not implicate the privileged communication, right? So that would not necessarily involve a communication from the defendant to the lawyer. And that's where I think the limitation should be, is those confidential communications. And with that, unless there are any further questions, I will rest on my brief.
No.
No.
Okay, thank you. Very
Thank you,
well
Bill.
argued. We appreciate your time. That case is submitted. Moving to the third matter on our docket today, docket number 369777, People v. Hack. I believe we have someone appearing remotely. All right, you may proceed.
Thank you. Good morning, Your Honors. May it please the court. Attorney Ann M. Lebrecht appearing on behalf of the defendant appellant. I do appreciate the request for Zoom being granted. For my arguments, I will rely on my brief unless Your Honors have any other questions, and I would like to reserve a few moments for rebuttal if necessary.
Well, with that, you have all kinds of time for rebuttal. That's fine. We will hear from the prosecutor and then we'll ask you any questions we might have. So let's hear from the appellate.
Good morning, Your Honors. Katie Went with the Kent County Prosecutor's Office on behalf of the people. I will do the same as Ms. Lebrecht, and I will rely on my brief unless the court has questions.
I do. Is there any world in which these two combined pieces of equipment still had value of $1,000 or more?
I apologize. I'm not sure I completely understand your question.
So what are the,
because of the depreciation, Your Honor?
yeah,
Is that what you're saying?
it was 5 years. I believe it was what did we have here? There were two pieces of
Like a
equipment.
window washer, right?
A power washer and a generator, Your Honor.
So a power washer and a generator. And at least in my practical experience, neither of those two pieces of equipment retain their value to a large extent over years. And these were at least 5 years old.
Correct. So the record says that they were at least 5 to 7 years old. I will admit for the bench, I am no expert when it comes to power tools, so I cannot provide a personal opinion about depreciation. But my position on that, Your Honor, would be that that was provided to the jury. He did admit that they probably depreciated in value. So the jury had that testimony to consider when the.
And that's interesting though, because then there was an objection by the prosecutor when defense counsel attempted to get into this, question of depreciation with the victim here. And the judge cut him off and the defense counsel basically just gave up. Why was it not ineffective assistance of counsel for the defense counsel not to do something more? Because I get at the beginning, if I remember right, there was a police report that originally pegged this equipment at 2,100. And you could say, okay, what's the likelihood that it's below 1,000? Probably not. But once you get into trial and the victim says that the combined value, I think, was around 1,400 to 1,500 when purchased brand new 5 years ago, why is that not an automatic red flag that this defense counsel should have said, oh, wait a minute, what was it? What was the combined value when the items were stolen?
I would say that in terms of ineffective assistance of counsel, the trial attorney in this case, Ms. Foster, did attempt to elicit, as Your Honor has pointed out, she did attempt to elicit questioning regarding their current value at the time of the offense or what Mr. Miskett would have believed their current value to be. The prosecutor did object at the time and the court sustained that objection. So I don't know
but sustained it over. I mean, the defense counsel didn't even offer an argument. She essentially withdrew. I don't think she said, I withdraw the question, but she basically said, okay, you got me. And then she went on. I mean, that's the time where she should have, kind of stuck to her guns a little bit, or maybe gone and, gotten some other evidence somehow.
Do you recall the record whether or not, I thought she did withdraw the question?
I can't recall off the top of my head. I apologize.
That's
I
okay.
just remember the objection
She
being
gave
made
up.
and
One
she
way
did
or the
not,
other.
I will agree with the bench that she did not make any additional effort after the objection was either sustained or she withdrew. She did not make an additional effort to go out and find evidence or push the matter further. And I would argue that if that was her sole theory of the case, that might rise to a level of objective unreasonableness. But as you can see from her initial opening statement, she had a theory of the case that was completely separate from the value of these items because she anticipated that the testimony would come in similar to the police report. I think that's reasonable. So her position really relied on that deputy's statement that he believed he thought he saw two people in the vehicle. She was hammering in her opening statement this element of knowledge. Did my client actually know that there were stolen items in the vehicle? Was there actual or constructive possession? And did he know that they were stolen? Because there was this second person that was believed to be in the vehicle who wasn't there at the time of the stop.
But I've seen case law that has said the defense attorney could do a wonderful job in most respects. But if they drop the ball on a key point, that alone could be ineffective assistance of counsel. So I have no doubt that this defense attorney did a great job on the other, like you said, the kind of her main defense at the beginning. But again, once it became clear that 5 years ago, this equipment was purchased for maybe at the top end, $1,500, that should have raised a red flag that 5 years later, this equipment, there's no way that it combined, it was worth $1,000. I mean, you go to a garage sale and you can get equipment like that for, $100 each.
I would respectfully disagree with the categorization that she dropped the ball because she did continue to argue to the jury that this should give them pause, that the prosecutor didn't prove beyond a reasonable doubt the price or the value of these items because of this question of how they depreciated in value. So she continued to harp on that, and she molded her trial strategy to that testimony for her closing argument that not only did I want you to focus on these two elements, but now I actually want you to focus on this third element as well. Did the prosecutor actually meet her burden based on this testimony? I know I couldn't get into or ask about the depreciation value. The court stopped her from that, but she did argue that, and that's exactly the argument that counsel's now raising on appeal in issues 1 and 2 is that the prosecutor didn't prove their case because of that specific testimony. So she took that strategy and argued that to the jury.
But her arguments were not evidence, were they?
Her arguments were not evidence, but I would submit to the court that the jury had the testimony about probable depreciation in evidence to consider, and then she used that testimony to make inferences in her arguments to the jury that they couldn't find that the prosecutor proved beyond a reasonable doubt, and the jury still came back with a verdict.
Okay, thank you.
Thank you, Your Honors.
Thank you.
Ms. LeBrecq, you have time for rebuttal.
Thank you, Your Honors. If I recall from the police report, the whole vague second person thing was definitely not the way to go. If it comes right down to it, and I use a lot of power tools myself. I'm having to be one of those women that like to do her own thing and make a lot of things. So I'm kind of aware of the value of some of these things myself. When it comes down to it, when you have cops that pull your client over, there's a chase and so on and so forth that ensues, you're kind of screwed. Not to put it in such lewd language, but you're kind of screwed. You only have so many things to look at. So when you look at the elements of this offense, one of the things is the value of the property. Why would you not, as any effective lawyer, go and look into what year these items were, when they were purchased, and do a Google search, eBay it. There's a million things to go out there. It didn't take me very long to find what I found. It took me a matter of seconds. Would not have been hard to figure that one out. It would have been, I'm sure the prosecutor on the other side would have been more than happy to give, whatever evidence they had of when the stuff was bought. To me, this was completely ineffective. There should have been something brought in. It wasn't exactly like it was impossible to get. And in this particular case, the basic of the fact pattern was, you've got to prove what the cost is. And in this case, she slipped up.
Okay. I think
Thank
we
you.
understand. Any other questions?
No, thank you.
All right, thank you. That case is submitted. Calling the fifth matter on our docket this morning, docket number 374980, Spectrum Health Hospitals versus Auto Owners Insurance Company. Please proceed. No, proceed, not be seated.
Got it. Thank you, Your Honor. Well, good morning. Good morning to each of you.
Good morning.
I just have.
Can you make put your appearance on the record, please?
Absolutely. My name is Jason Osborne. I'm here on behalf of the appellant Auto Owners Insurance Company.
Okay.
I have two brief issues to address to the court. And the first, I think, is very straightforward. And that is the trial court's order on this got the law absolutely wrong. Judge Mims cited the correct statute as it pertains to attorney fees. She cited the correct authority under which that is analyzed, and then completely disregarded that and simply applied the standard of review for the assessment of penalty interest. And so in making that ruling, the order completely fails as far as the analysis goes. I don't think that's fairly controversial. I think the order spells out very clearly how this analysis took place, and the error is very evident. So I think the question in this case really comes to the second issue is, did we achieve the correct result despite the wrong analysis? And what I put to this court is that
So
no.
you're saying it's wrong. You don't think she went to the reasonableness test?
Correct. Yes.
Yeah, I looked through the record and I disagreed with that. I thought that she did look at the fact that there was notice provided that the policy was in place at the time of the accident. So I was trying to line the two up when I was preparing for this to try and figure out, explain to me your perspective on how she missed it.
Sure. So the ultimate holding of the court in this order is not that it was unreasonable because of a delay, because of knowledge of the policy from this one phone call to Progressive. The finding, the conclusion by the court was that it was unreasonable because it wasn't paid within 30 days, drawing directly from 3142, which pertains only to penalty interest.
But part of her analysis, before she got to the ultimate pronouncement, did include, the consideration of the facts.
Right. Then, and I agree, there's definitely recitation
Okay.
of facts in the order. But when it comes to the analysis and how those facts apply to the law, that's where the miss happened, right? And the trial court did, it's one thing to acknowledge the facts, but then if you don't apply those facts to the law correctly, that's a failure of law. It's reversible error. And that's what happened here. She noted the allegations from the plaintiff provider. But then when it came time to decide, okay, do the attorney fee penalties apply in this case? Her finding in that instance wasn't that they had the information and that they needed to make a reasonable decision. It was unreasonable to deny benefits or delay benefits at that point. The analysis was payment was not made within 30 days, period. And that was what the court found unreasonable and entered the order. So that's the issue I take from the procedural standpoint. In terms of, and I think this next issue is going to get to more of the substance of what we have here.
Okay.
Substantively, we're talking about a complaint of a delay in payment over the course of about a year while an investigation is taking place. Now, the thrust of the plaintiff appellee's argument is that there was a phone call to Progressive early on, a few months after the accident happened, and there was a statement from the representative that said, oh yeah, our policy is valid. The problem is when auto owners asked for a copy of some kind of documentation demonstrating that, they said we can't provide that without authorization from our insured, right? And then auto owners then proceeds diligently over the following year to get that documentation from the insured and from Progressive and through discovery through this case at the lower level. And all that was delayed and refused. That's the only reason payment wasn't made more promptly, because we didn't have the documentation. And what it comes down to is a verbal statement from a random representative at Progressive. The end all be all of what an insurer can ask for, or is it reasonable for them to require some kind of documentation?
So do you normally not accept verbal confirmations?
I think it's a good starting point for sure. But
Do you accept them though, in any circumstance?
do we accept verbal confirmations in any circumstance? I mean, it would depend on the circumstance, Your Honor. Something critical, like if they're going to find themselves assume liability for an insurance claim, especially for someone that's not their named insured in the policy, I think it is normal to insist upon documentation.
Is it, but, and, you know, I get how that might be something between your client and Progressive, but isn't the whole point of no fault that if there's coverage, insurance company pays, and then the insurance companies kind of sort it out later on, you know, maybe if there was a mistake about which insurance company paid, then the other, you know, then there's an issue that gets resolved. So again, Progressive, you had a representative from Progressive said, yep, this person was covered. Wasn't that then incumbent upon your client to pay? And then if 6 months later, if, you know, it turns out that he wasn't, or there was some, you know, mistake there, then the insurance companies sort it out. But I thought that's the whole fault. The whole point of no fault is to get insurance companies to pay promptly and then figure it out on the back end.
Yes, in terms of priority disputes, Judge, you're absolutely right. This is not a priority dispute. This wasn't a contest between whether Progressive.
So that whole kind of incentive structure only exists within the priority structure. And if we're outside the priority structure, then the delay that occurred here was reasonable.
Yeah, well, I mean, that's in a sense, yes. I think that principle still holds true, that once an insurer has reasonable proof or their investigation is no longer reasonable, then they're penalized through the assessment of attorney fees. But that's separate from the priority dispute. Again, I want to be very clear here. This wasn't a contest between Progressive paying and auto owners paying. Progressive was never going to pay. Progressive was the insurer of the motorcycle and under the priority rules for motorcycle. So the question was then, was auto owners, was the claimant that plaintiff rendered services to entitled to receive coverage for this, particularly within 3113, the exclusion for the operator of an uninsured motorcycle, right? That's the ultimate question here. And that was the purpose of the investigation that took place over the ensuing time. So that's where the identification of existing coverage became critical. And I think important enough to warrant a demand for documentation that this policy did exist, because we had conflicting information. We have a verbal statement from Progressive saying he's covered, but we also have a statement from the insurer who overheard the patient say that he wasn't covered.
Yeah, which is a very, no, it was a very non-specific statement that she made. She didn't, you know, it was not, you had from Progressive, he is covered. From her, she was like, I just think he's not covered because he said it was, you know, something about, I forget the exact verbiage, but he was like, it was activated, I think was the.
Said is the insured, the auto owner's insured overheard the patient say that his policy wasn't activated. And when we finally got his, well, I really think that this reticence was really the importance of it, the justification for it was demonstrated when we finally got the deposition of this individual who explained that this was the first day he was riding his motorcycle after it had been in the shop for 6 months and hadn't been using it. It was the first test ride for him. And then in April, the following year, when we finally got the policy, at least some of the policy documents from Progressive, frankly, Your Honor, I wish that disclosure from the other side had been limited just to the declarations page, because it would have been paid right then and we wouldn't even be here. But it included a greater part of the claim file, which included correspondence from Progressive saying the policy was being canceled for non-payment effective the morning of the accident, right? And I think that.
But you guys didn't pay because the lady that hit him said, well, he might not have had insurance, when Progressive said he had insurance. The insurance company.
Right.
Who insured him said he had active insurance right then. Why was it more reasonable to listen to the lady that hit him?
Well, there was no denial on the basis of that. Which prompted the investigation. Progressive wanted to get confirmation that this policy existed.
Is it really within, I mean, I don't know. It's odd that an insurance company would say, yes, this person is covered if there's literally any question in that insurance company's collective mind that there was not coverage. They're not, you know, in my experience, insurance companies don't just willingly, suggest coverage when maybe there's no coverage here. I mean,
And in this instance, Your Honor, I would agree with you, but in this instance, Progressive had no liability in this. They admitting or denying that there existed coverage, it was no skin off their nose whatsoever. They weren't going to be liable for this. This is on auto owner's side. So basically it comes down to 1 5-minute phone call with a representative who's not necessarily even the adjuster on the claim, may not even have knowledge of the accident in the first place, doing whatever they do on their end and say, oh yeah, there's coverage. I mean, there can be a computer error. There can be.
Then why'd you
a
make the phone
misstatement or-
call?
I'm sorry?
If it's so unreliable, why bother making the phone call? Why not just ask for written, something in writing from the get-go? It doesn't make
That's
any
what it-
sense to me.
That's the phone call. That was part of the purpose of the phone call. You call up, do you have coverage? Yes. Okay, can we get a copy of the policy of the declarations page? No, you can't. Well, okay, then I guess we'll try and get authorization from your insured. And repeated contacts. I have a half dozen contacts over the next few months with the patient's attorneys saying, oh yeah, we'll get you the stuff. And then they never do, over and over again. We wrote discovery. We had subpoenas to Progressive and to the individual that weren't responded to. I mean, auto owners was very diligent in trying to get this required information. And when they finally got it, they paid the claim in full.
okay. I think we understand this issue. Is there anything else you want to touch on?
No,
Or
those-
save some time for rebuttal?
I will say sometime, but those are my main points and really fairly straightforward case, I think, ultimately.
Okay,
Thank you.
thank you.
Morning, Your Honors. Ryan Duffy on behalf of the appellees Spectrum.
Morning.
I will try to keep it real brief. I think our briefs explain our position. Couple things I'd like as I speak to the panel here is the backdrop is they took their shot and lost. If you look at the timing of the claim happens. They call Progressive. Progressive confirms coverage. That's in June of 2023. My client eventually submits stuff in August of 2023, gets a denial. November, we have to file suit. Supposedly diligence is happening. My office subpoenas Progressive's records and gets a response. In those records is a confirmed deck sheet confirming what the Progressive representative said. That was in March of 2023. If you look at the record and the testimony of their adjuster, she says, well, I got that in June of 2024, and then I made another call, and they confirmed again that there was coverage. They start paying my client's bills on July 15th of 2024.
When should they have started to pay, in your opinion?
They had, in our opinion, they had reasonable proof in August of 2023 when my client submitted its bills and records, and they had 30 days after that.
What, was it not reasonable for the insurance company here to want something more than just a verbal statement from Progressive? I mean, and then, it sounds like they reached out, they have records of reaching out to the claimant's attorneys. And frankly, it just sounds like the claimant's attorneys dropped the ball. I mean, this sounds like something that they should have been able to provide pretty quickly.
I would tend to agree with you, except Your Honor, that's in our view, based on the law, that's the patient, we're the claimant. We gave them everything.
Okay.
This goes back to.
You know what I meant, though.
Yes, I do. And I don't mean to be
patient.
disrespectful at all. I argue this all the time with insurance
fine.
companies. So, but what I would say is they hung everything on their insured's hearsay statement that this patient said at the scene he didn't have coverage.
Well, and once you filed suit, they could have subpoenaed.
That's exactly, I finally said, all right, our office will subpoena, and it comes back.
And that would have been, you filed suit in November and
I subpoenaed pretty quickly and got an answer in March is when we got the documents. And I immediately sent it to opposing counsel's office and said, look, here's the deck sheet. Yeah, there was a cancellation notice, but that doesn't mean that the policy was canceled. So then they go on this rigmarole of, well, now we need his DEP. They took his DEP on July 18th of 2024. They started paying on
they
July
paid before.
15th. So they paid before. So other than the deck sheet, they had the same thing. So it took 2 phone calls and a deck sheet over a 15-month or 12-month period to make payments. You can't you don't get to say, well, we diligently made an investigation for over a year and then you lost. And going back to the court's order, if you read the court's order, the judge cites the proper case law that says, look, once you have reasonable proof, you have to pay. And then we can decide at the time of your denial or failure to pay, whether it's unreasonable, and you can only get out of it. In this case, I believe they're focusing on a factual uncertainty. I would say a phone call is reasonable proof. When a representative from an insurance company says there is coverage. I understand if it was the patient says, no, I have coverage, I need documentation, but an insurance company says that, yes, there is coverage. They have no reason, Your Honor, hit it right on the point. They have no reason to, if there is a remote possibility that there is no coverage, because there is a collision claim with this that didn't end up getting paid because I think he didn't have collision policy, but they're not going to admit to coverage. They're just never going to admit to coverage unless they know it. And they're in front of I presume, a computer screen. So I think the court absolutely got it right. I think they're unhappy that the court didn't go into deep detail as to what the factual uncertainty or why they found it unreasonable. And even then going back to the right result, wrong thing, they haven't paid penalty interest on this. They had reasonable proof. And if you don't pay penalty interest and refuse to pay it, that's frivolous under the statute too. So entitling us to attorney fees. So unless the court has any questions for me.
Nope, thank
All
you.
right, thank you, Your Honor.
You have time for a brief rebuttal?
There are like two short points here. The first being this deposition. The deposition wasn't first noticed for July of the individual. The notices first went out in March earlier that year before the policy documents even were brought in. Really delayed deposing him because we wanted those policy documents to ask him about them, if that were the case. But it worked out that he didn't show for the first deposition. We received the policy documents. We renoticed him for the deposition. He failed to appear for that one and finally got him rescheduled in July and got him in. And at that point, the analysis at that point really became, and there was a shift here in the issue. Once we got those policy documents from Progressive finally and reviewed them, we were able to verify that there was a deck page showing that the policy was in effect, but then it raised this additional question of this non-payment and cancellation. And the analysis from that point was, well, was it canceled? Was it not? And then the decisions ultimately made, like, do we really want to put ourselves in a position of arguing for or against the existence of a policy by another insurer? Do we even have standing to do that? And so rather than pursue that, the decision was made to pay the claim, and that's what was happening. It was done properly.
Okay.
As far as the pay and chase thing that was mentioned on rebuttal here, there's no ability to pay and chase. The payment was going to be made to or for the benefit of the individual, not the insurance company. And there's no recourse for auto owners to recover benefits paid in this instance from Progressive, who wasn't liable at all.
Okay.
Other questions?
Yeah.
Thank you so much.
Thank you. Case is submitted. Calling the sixth matter on our docket today, docket number 372750, Great Lakes Energy Cooperative versus the City of Petoskey. Mr. Asher, when you're ready.
Thank you. Good morning, Your Honors. May it please the court. Kyle Asher on behalf of Great Lakes Energy Cooperative.
Good morning.
Morning. I'd like to reserve 2 minutes for rebuttal. This case obviously turns on a discrete issue of statutory interpretation, and I acknowledge it's somewhat unusual in a statutory interpretation case to lead off with a bunch of the policy underlying the statute, case law interpreting that policy.
It is an interesting approach.
Judge Schwartzel, I heard in the first case, your comments about legislative history, but I do think there is separate case law acknowledging that statutory history is different. That's from Ray versus Swager. That was a textualist Supreme Court in 2017 interpreting a Scalia and Gardner treatise that, when the reason we opted for that approach is because when a statute is amended, courts says not that you don't usually, but have to pay particular attention to statutory amendments and really try to get at what the meaning of that amendment was.
Well, it's one thing to say that the course of the statute changed over time. It's absolutely appropriate to say, well, okay, it changed. That means something. But you also included, I believe, a letter that you cited to, and when I talk about legislative history, I'm talking about, when legislators give floor speeches, when they testify in front of a committee, or if you have a trade group who submits a letter. That's the kind of stuff that I've seen a lot of cases that suggest that we really shouldn't be looking at that at all, or if we do, we give it pretty minimal weight. So do you have a strong textualist argument of this is what the law currently says and this supports our position? Or do we really have to go into policy and what trade groups have to say about this?
I think not necessarily what trade groups have to say, but the fact that this was amended directly after City of Coldwater, that's the policy and the history that we're looking at. Textually in a vacuum, and I said this to the circuit court, I'm not going to pretend otherwise here, had subpart 11 from Rule 411 been imported into 124.3, I would have an easier argument here today. I'm not going to pretend otherwise, but I don't think that has to be there to get to the result that we're asking you to get. And to get there, I think this court would have to do essentially what Justice Markman's dissent in Great Wolf Lodge sort of criticized this court in Consumers Energy from doing, and the majority in Great Wolf Lodge from doing. And that is really what those courts did explicitly in Consumers and more implicitly in Great Wolf Lodge, was to equate the definition of customer, buildings or facilities, to include land. Again, policy, knowing why the competition bars are in place, I think helps to get you there. From a strictly textual perspective, I think you would have to look at, I think, the word facilities to include land.
And that in a vacuum might be a decent argument, but then when you look at the regulation, which there's no question that this statutory definition was based on the right, 411 and I understand Coldwater, but Rule 411 makes a distinction between, or it uses the terms buildings and facilities, and then it talks a little bit later about premises.
Yep.
And are we supposed to ignore that when a body wants to refer to premises instead of just the facilities or a building, it actually uses the word premises?
Yeah, and again, I think my job would be easier had that been there, but I do think that is essentially what this court did in Consumers versus PSC, and what Justice Markman noted the majority did in Great Wolf Lodge. Because if you look but before getting to subpart 11 in those cases, they had to interpret what the term customer was under Rule 411. Subpart 11 only provides a right to serve the electric load on the premises of that customer. And so if there's no customer, there's no right to serve in those cases either. If customer meant buildings or facilities and didn't include the land whatsoever in those cases, there would have been no customer in either of those cases to end up getting to the result that the court did. And so again, not to rely too heavily on a dissent that ultimately disagrees, but I think when we're looking at what the state of the law was at the time before City of Coldwater to say if the legislature is amending the law to get back there, I think that's a good place to look. And Justice Markman recognized Consumers Energy explicitly did equate customer with land. It said the customer was the Meyer property on multiple occasions there.
But that was under the guise of 411, right?
That was under the guise.
And 411 does include that premises expansion.
It does, but again, that was in interpreting the term customer under 411 before getting to subpart 11 under 411. And so I think that's my best textual argument is you're going to have to, agree with what this court did in Consumers Energy and what Justice Markman framed the majority as doing in Great Wolf Lodge. I think that's my best textual argument. I do think the underlying policies preventing, avoiding duplication of electric facilities, I think that is a really important lens to look at the text through. And if you do disagree with me on the text, I think the only other way that we get to, the level playing field that has been discussed is if there's a level playing field, then everybody has the right to compete, and regulated utilities have the right to go on to the land of, that's being served by municipal utilities. Every time a new building's constructed, gloves are off, we can compete. Anytime a house is torn down in Lake Michigan, and a new mansion gets torn up, that's a new building or facility, and there's going to be full competition there.
I mean, isn't the response to that what was attempted in 2018 just didn't do what the trade association thought it was going to do in terms of creating this level playing field? It kind of went halfway, but it didn't go full because it didn't include anything about premises in the definition. It was just that effort back in 2018 wasn't sufficient, in I think your client's eyes.
Yeah, and for all the reasons we said in our brief, I'm not going to reiterate it. We think what's there is sufficient to get there. And if you disagree, I know I also heard you today get up and say the legislature is not passing laws anymore. But this was something that the first time around.
I'm sure my friends in the legislature will be happy to hear that.
My client as well. So, but the first time around, the legislature did. This is really an important issue in the state, dating back to the 1960s, where these policies have been in place. And I think if your honors don't think that they went far enough, I think calling that out would be helpful to the industry, to my client, to say, if this is really what you intended to do and you didn't go far enough, this is what you need to do. I think that would be helpful. So.
Any other questions?
No, thank you.
All right, you'll have time for rebuttal.
Thank you, Your Honor.
Nolan Moody on behalf of Appalachia City of Petoskey. Good morning, Your Honors.
Morning.
There's a
Morning.
good morning. Didn't mean to interrupt. There's a very simple reason why the court should affirm, and Judge Swartzley, you really hit the nail on the head. The premises rule, which comes out of Rule 411, does not exist in the definition of customer under MCL 124.3.
Is it fair to say if we were in Rule 411 world, it probably would be covered?
Yeah, absolutely.
But because we're not in Rule 411 world, and the definition is just different here, it's not. Is that a fair juxtaposition?
I agree with everything you just said, and I would add that when you say the Rule 411 world, what we're talking about in my mind is MPSC regulated utilities and a municipal utility, because Rule 411 is MPSC regulated utilities, and they have this rule. Municipal utilities, it's undisputed, are not subject to the MPSC's jurisdiction, and they don't have this rule. And so the debate becomes, well, and Mr. Asher is very candid. He admits that language does not exist anywhere in a statute or anywhere that applies to municipal utilities. So what the argument for Great Lakes becomes is the definition of customer was amended in 2018 in a manner that essentially infers that the premises rule should come into the definition of customer. But again, just to repeat myself, it didn't. So the rule doesn't live there. And the Coldwater case is, I think if we start there, we can almost end there. And it's sort of, that's the full discussion. Because in my mind, the Coldwater case still controls. The Supreme Court overturned Great Wolf Lodge in Coldwater, and it said Rule 411 is an MPSC rule that does not apply to municipalities. That's one holding that came out of Coldwater. Then there's a second holding that comes out of Coldwater because the Supreme Court said, okay, now the premises rule doesn't apply. It doesn't work for the municipal utilities. What does apply? There's two statutes. They're called no switch statutes in the utility world. It's 124.3 and it's 460.10Y. They do the inverse of one another. One of them says munis, you can't take MPSC regulated utilities clients. The other one says MPSC regulated utilities, you can't take munis clients or customers is the word in the statute. You can't do that. So the Supreme Court was trying to figure out if in the particular circumstances there, can the customers move to a different utility? And the issue became that of these two statutes, they only define customer in one of them. The other one was just silent. So for the MPSC regulated utilities, there was a definition of customer that meant the buildings and facilities served. On the municipal utility protection side, no definition. So the Supreme Court says, well, in that circumstance, we go to the dictionary and we see what's in the dictionary. And what the Supreme Court did is it said customer on this statute is going to mean the individual or entity. So what happened in the holding was you have these two statutes that are substantively supposed to do the same thing. They're supposed to protect switching for MPSC utilities here, municipal utilities here. But it changed the definition of customer so they were different. And you can imagine in the utility world, it was a big difference because protecting the municipal customers, the customer was the building. So if we sell our house and somebody else moves in, for the munis, the customer stays the same because the house is still there. But on the MPSC side, the customer was the building. And in the utility world, that's what everybody wanted, munis included, because they don't want that much turnover because the house stays, the customer stays, and you're protected. You can't have switching. So that's what came out of Coldwater. That was, and I know Judge Schwartzel, you already
And when,
mentioned.
in the definition, when it talks about, it doesn't include the individual, the association, partnership, corporation, governmental body, or any other entity. If it had, I mean, I could see where, you know, a partnership, the partnership would include everything the partnership owns in terms, you could read that to mean premises. Is that, but that's not, that's explicitly excluded from the definition of customer here, correct?
Well, correct in the sense that it is explicitly excluded.
Right.
Absolutely. And I think that all those the partnership, entity, individual, what that's all referencing both before Coldwater and after in those definitions, because that definition already existed elsewhere, was the distinction between whoever is in the building versus the building itself.
I got you. Okay.
And that's what the definition was always designed to do. And that's where Coldwater, the Supreme Court, it separated the two because the one didn't have a definition. And the Supreme Court said, we're actually going to change customer to whoever's in the building itself. And that's where the 2018 amendment came from. That's where you see Jim Weeks' letter that council cites. And I agree with you, Judge Schwartzel, that's not even legislative history. That's not even a legislator speaking on something, let alone something to consider here. But what Mr. Weeks was saying, I think is still applicable in the sense that that even playing field that's being referenced is not the premises rule. It's not adding that protecting the land goes along with the customer. It's putting the same definition of the two no switch rules in the statutes so that they work the same. That created the level playing field that everybody wanted. The premises rule was the first holding of Coldwater, and the legislature knew it at the time. I don't disagree with Mr. Asher that shortly after Coldwater, there was an amendment to 124.3, but the timing proves even more our point that the premises rule didn't go in. And the reason why I say that is because the premises rule was right at the forefront of Coldwater. It's the first holding. The Supreme Court said the premises rule is the idea that if you serve a customer on the land, you serve the whole parcel, every customer that comes after that. And that rule does not apply to municipalities. It had just happened and the legislature knew it. It was right in front of them. They also had the language from the premises rule right in front of them. Everybody knew what that was. Judge Schwartzel, you just mentioned it. It's the word premises is put right into the statute. It specifically says the first electric utility or co-op serving the customer pursuant to these rules is entitled to serve the entire electric load on the premises of that customer.
And that's Rule 411.
That's Rule 411. The legislature had that language available to it. It didn't add it. The legislature also knew the rule didn't apply to municipalities. It also could have just said it applies to municipalities. It didn't. Instead, it focused only on the second holding in Coldwater, which is the definition of customer, because the Supreme Court didn't have one, so it made one. And the legislature said, we got to make this even. We got to put this back on the same.
I think we understand.
All right.
Any other questions?
No, we understand.
Thank you.
Mr. Asher, you have time for a brief rebuttal.
Thank you, Your Honors. I'll be very, very brief. I do just want to re-emphasize the importance of this case in the industry. I do think this really will represent a sea change in how at least my association, I think how the MMEA understood the amendments back in 2018 to do. And whether it's through a loophole or just we misunderstood things, I think opening up competition to both parties now is really just inconsistent with dating back to the 1960s. It's going to change.
Is there any evidence in the record to suggest that since 2018, everyone in the industry understood that the definition of customer would include premises, and that this just kind of came out of the blue?
I think the best evidence of the record is just the lack of litigation leading up to this point. I mean, this is the first time that's happened, and immediately after it happened, there was a lawsuit here. I mean, my clients have never as long as I know, ever attempted to serve on a parcel of land that a municipal utility is already serving.
Gotcha.
And so I think, like I said, I think it's going to be maybe to the detriment of customers and ratepayers in the state if the circuit court's ruling is correct. But if the gloves are off and there's competition, that's really going to represent a fundamental change in how our utilities operate. So,
Okay. Any other questions? All right.
Thank
Thank
you,
you.
Your
We appreciate it. It was very well briefed and well argued, and that is helpful for our decision. So that completes our 10 o'clock. We're going to move to the 11 o'clock, but before we do that, we're going to take a brief recess. Maybe seated. Thank you for your patience. We will call the 8th matter on our docket today. Docket number 374804, in re petition of Hillsdale County Treasurer for foreclosure. Mr. Visser.
Thank you. If it pleases the court, Donald Visser on behalf of the appellant, Mr. Carpenter, I'd like to reserve 5 minutes if I may for rebuttal.
Sure.
I'm going to just try to emphasize a couple of things that are not stated in my brief or not, maybe not stated as well, and primarily focus on the Michigan Takings Clause, which I do not believe was covered in the In re Muskegon case. Judge Schwartz will know better or not than I will whether it was in there or not, but my interpretation of the In re Muskegon case that it excluded a separate consideration of the Michigan Takings Clause. And we all know that the Michigan case law has given notation to the fact that that takings clause in Article 10, Section 2 provides greater protection than that of the Fifth Amendment. But there's not a whole lot within Michigan jurisprudence that describes what that greater protection is. It goes not toward the damages that are awarded or just compensation, but rather to the restriction on government to take property. And the only thing that I was able to find really that addresses that is in Raffaelli itself, where the court said, we must keep in mind that the Michigan's taking clause has been interpreted to afford property owners greater protection than its federal counterpart when it comes to the state's ability to take private property.
Was the state takings clause argument made in the initial trial court in this case? Before in the initial case in front of the circuit court?
I do not know if it was, Your Honor, you're referring to before the first appeal or after?
Yeah, no, the first appeal, right? When you file it, when you filed this case originally, did you make a Michigan takings clause argument that was separate and distinct from the federal takings clause?
Yes, there was mention made of that, but it was obviously not developed nearly at that time as well.
Okay, and then I assume that you preserved that argument in front of the first appellate panel, correct?
Yes, we did, Your Honor.
And so when that appellate panel in Hillsdale Treasurer 1, we'll just call it, said, quote, none of respondents' constitutional arguments convince us otherwise, doesn't that suggest that they looked at all of your other constitutional arguments that they hadn't explicitly discussed and said, we're not convinced by any of them, and therefore remand consistent with Muskegon?
That might well be something that one could take from that description. But
I'm quoting. It's a quote.
No, I understand. But if the court has not ruled on the issue, then it's not law of the case. And so couldn't the panel say we are not convinced by any of respondents' other constitutional arguments, therefore we're not going to address them? I mean, that we do that all the time. Well, I think there's a flaw then if it's done in that fashion and the issue is raised where a separate constitutional issue is made under the Michigan Constitution and it is not addressed. If it just simply says we are not going to address it, it's not addressed. And so
It
if,
says we're not convinced by it. It's not it's, you know, I've seen, I think it's analogous to a sentence that says the remaining arguments are without merit. That is addressing it. It's just not addressing it in a fulsome manner.
I'm not sure that it is addressing it in the way the Constitution requires an opinion to be issued to address what the issues are and how they're resolved. I understand it's disposing of it to get to the end of the case, but that's, I think, why you have unpublished decisions and so forth. And if it's not precluded, the remand in this case was not to enter, it could have said to enter if everything was disposed of. The remand in this case could have said to enter an order disposing of the claim. I mean, the Michigan Supreme Court did so recently in Hathon and sent it back and said, you're going to dismiss it, and gave some directions as to what is to happen. In this instance, it said to be done in accordance with In re Muskegon. And I believe that what it means then is that whatever is enunciated in re Muskegon is the controlling issues to go forward, and that if those issues are not addressed in re Muskegon directly, that they're still available to the court. And of course, that doesn't address the issue of the impact of Cully versus Marshall, which is a subsequent decision to in re Muskegon, which indicates that after for a forfeiture, there has to be a timely post forfeiture hearing, and that of course doesn't occur here. But that fits in again with what I see as the dilemma in Michigan as to its takings provision is that Michigan government can't take until it first pays. And so what you have is this problem with ownership. Raffaelli says the ownership of the property belongs to the individual. MCL 21187B1 says that neither the treasurer holds as trustee and the county has no ownership. So we have going into these sales, we have ownership with the individuals. How does that get over to the county? At some point, and the police, the county's position on it would be, well, it only occurs when we make a final decision. Well, that would mean sometime after July 1. Sometime after July 1, a taking occurred. If you accept that proposition that a taking occurred, now you have to measure that taking by Article 10, Section 2. Is it permissible? So this all comes after the notice provision. Sometime afterwards, we know that there is a taking when supposedly this possession ripens into some type of ownership, because the statute doesn't provide for ownership. 78T doesn't convey ownership back, say, well, if you didn't file by July 1, the property is now owned by the county. Instead, we have on page, as I say, on page 20 of their brief, they're acknowledging that it's only when a final decision is made to take. Well, we know by definition that doesn't occur before the July 1 date. So what I'm looking at is for some internal consistency when we look at Michigan's takings clause, how in the world government can do something that is not authorized to do if we look at what the limitation on its power. It can't get there from here using a common phrase.
Am I correct that Muskegon treasurer, the cert was denied?
I'm sorry.
Muskegon treasurer, in re Muskegon treasurer, am I correct that cert was denied by the U.S. Supreme Court?
It was the conference on July 9, along with
like a few weeks ago, it was denied.
Yeah, there is a pending motion that's being handled by Pacific Legal. There's a pending motion for reconsideration,
Gotcha.
but the odds of that are well, very low.
Yeah.
There is one case, however, that is a calendar case that may have some impact. That's Pong versus Isabella County.
That deals more with fair market value and how much or what the treasurer or what the county can sell it for, correct?
It comes down with the process, it comes down with the process, but in light of is an auction appropriate measurement of damages. It's not a limitation on power. It's compensation or just compensation and Eighth Amendment. Those are the two issues that are involved there. There's some indication that if you read all the pundits on it, that they can't get to the determination without having some implication on the constitutionality of 78T. That waits to be seen. I don't know. The other issue that we have, of course, is the due process, the notice issues. We believe that issue is pretty clean at this particular point after in Ray Kent County, or what I call Brott versus Kent County, which shows that in Ray Muskegon is not all encompassing to include notices. In this particular.
I thought there was some indication in this record that your client admitted that he got notice.
Well, that's entirely
Wasn't there that admission in front of the Michigan Supreme Court? On Hills, the first time it went up, I think after the panel held the way it did, then there was an application for leave before the Michigan Supreme Court. If I recall correctly, something in that record in front of the Michigan Supreme Court, your client, either in an affidavit or otherwise, admitted that he received timely notice.
I don't believe that to be the case, and maybe I can ferret down a little bit into an analogy that I made in front of another panel, and that is a stay in your lane type of analysis, that we're looking at real property, which there was a notice for, and for personal property, which is really what Brott is addressing, which is the surplus proceeds. Two distinct pieces of property.
But that's not what Kent County didn't say that there had to be two different notices. As I recall correctly, the question in Kent County was, there was a question of fact, whether that notice with regard to, as you indicated, the real property, whether that notice under 48 T or M or L, I forget which one, whether that was even done. But here, I think your client confirmed that he at least got the notice that's provided under the statute with regard to the real property. Is that fair?
That is fair, Your Honor, but that doesn't address whether does that notice give information as to surplus proceeds, identify that there will be surplus proceeds, and that you will lose your surplus proceeds if you don't file a notice. And you get quite a bit of confusion within the typical notices that was sent out by many of these cases were subcontracted to Title Check. And the notices came out, and across the top, it said, you have lost all of your equity. Very, very bold and distinct. And then down beneath, it starts talking about that there might.
What occurred here?
But that's that. I mean,
Sorry.
that's okay. But, in terms of the distinction that you just laid out for us, that's actually correct. But there's, this other personal property that is left. And those notices that you're talking about do go on at the bottom to say, you have this time period, you can file this paperwork and have this claim.
Well, there's a couple of different notices that are typically sent out, and I cannot speak as to the second notice. That would be after the sale. I'm sorry, after the foreclosure, after March 31. The one beforehand talks about the foreclosure and so forth. And that's the one I believe that we referenced having received relative to the real estate. But my interpretation and what I argued in Brott or in Ray Kent County is the fact that those notices are not adequate to address, when you put everything together, to identify the fact that there will be surplus proceeds and they belong to you, in light of the fact that you have put out in front, you have lost all equity. And if you notices, constitutional notices have to be derived toward your intended audience. And if you have people that cannot read or read very poorly or whatever their circumstances, and they get notice and say, you have lost everything. And then there's something, people who had an interest in the property before at the bottom, before the sale, may be able to entitle, and they talk in abstracts. They don't say that there will be surplus proceeds. They talk in abstracts if there were. It's as I've said, if the Consumer Protection Act applied to it, it would certainly go down in flames. But so when you get there, is it adequate? Is it constitutionally adequate as to that property? That's distinct. That's personal property. That's distinct as to whether it's adequate for the real property. And I think from footnote, and Judge Schwartz will know better than I do, but from the way that I read footnote 1, is that was envisioned, at least at the time of In re Muskegon, as being kind of a unitarian process that kind of went along, not recognizing the difference between real property and personal property, which is the surplus proceeds. So that's why I think the analysis has to be done in regards to the surplus proceeds, which is personal property. Does that now meet the constitutionally mandated requirements? And there's some suggestion in Ray King County that if it follows the statute particularly clearly, that it probably meets constitutional muster. But all the notices that I've seen never say, if you do not file your notice of intention by July 1, you will lose your right to personal property. It says you have a right to assert. There's no consequence of failing to file the July 1 notice. So that's one of the aspects I think that's implicit or expressed actually in King County.
Okay. Any other questions? All right, you'll have time for rebuttal.
Morning to the panel. Douglas Curlow on behalf of the Hillsdale County Treasurer. Of course, my fundamental position laid out in the brief is that this is a clear attempt to get a second bite at an appeal that was already taken and resolved by this court. There should be no mistake. This court, in the original Hillsdale County case opinion, said we reverse and remand for entry of judgment consistent with Muskegon Treasurer. This court had already analyzed Muskegon and said enter the judgment. That's what we had entered. Now suddenly we have Carpenter saying, oh, well, I can appeal that new order because it's a new final order that I can appeal. If that were the case, every time this court remands a case for entry of judgment, then that order gets entered. There could be a redo of the appeal. And make no mistake, this is definitely a redo of the appeal. The argument is that this court's original decision should not have relied on Muskegon, that this court was wrong in its original Hillsdale 1 decision to rely on Muskegon because Muskegon was wrong itself. And so this is an attempt to redo appeals that the Midkiff case versus Vanderwall that I cite in the brief, res judicata applies to a decision of this court as much as it applies to a trial court decision. You can't get a redo of a case. To go to what was mentioned at the last part of the argument regarding the
notice.
The notice, correct. Page 24 of our appendix is page 7 of Carpenter's application to the Supreme Court. The way he phrases it, the county entered a judgment of foreclosure on February 26, 2021. The county then sent Carpenter a notice of foreclosure. And that's the notice that he admits receiving. And that notice, what's in that notice? We have in this notice 2 points where it says you have a right to claim the remaining proceeds that will arise from or if any arise from the foreclosure sale. At 3 points, it says you do that by filing form 5743, identifying the form by number 3 times. It also says at 3 points, 1, 2, and 3, that you have to do it by July 1st. And it gives the year 2021. How much more idiot proof can you make the notice? I mean, this is as explicit and as clear as it could possibly be. As counsel said in his argument, what's required.
If we even reach that issue.
If you even reach that issue. And like I say, I don't think I need to rehash my discussion in the brief about reaching that issue.
Do you read the prior panel's statement that, quote, none of respondents' constitutional arguments convince us otherwise, close quote, as essentially a sweeping declaration that all the constitutional claims are without merit, enter the judgment according to Muskegon?
Comprehensive as far as I can see. I mean, that's certainly how we would interpret it every time this court makes a decision, or as your honor pointed out, sometimes they say, different phrasing that's used, but oftentimes points are decided and dispensed with without elaborated discussion of them. I mean, that doesn't leave them all open for a redo. And I would just make one other point. A point was raised here today that we've got a distinction between the real property and the surplus proceeds, and they haven't arisen until after the sale has happened. I would cite this case to the Sixth Circuit decision in Howard versus Macomb County that I cite in the brief. In that decision, they make the point that the whole purpose for these 78T procedures is to prevent the taking from happening. If the claimant follows the procedures, there will be no taking because the procedures will result in the payment of the surplus proceeds and they will not be taken. The problem here is that despite the notice, the procedures were not followed in the timely manner that was required by the statute. I'd cite the court to the Schaefer opinion by the Supreme Court, Schaefer v. Kent County, where they were adamant that the timeframes that were required by the statute should apply.
I mean, I wish you had not chosen the phrase idiot proof to describe this, because I think it fails to have any thought or compassion. You know, your home is most people's biggest investment. It's where the majority of their funds lie. And losing a home has got to be a highly traumatic event. And whatever gets that person there, you know, they've already had an enormous amount of trouble in their life. And to then take the proceeds from the sale, which the law, you know, clearly allows, you know, and just foist it entirely in this way that, oh, well, they weren't such an idiot, you know, because they can't read all this stuff. This stuff's complicated, and it's not just about the words on the page. It's emotional, it's difficult, it's overwhelming, and I just wish that you would not have chosen that phrase.
I have one rejoinder I can make because I've encountered that discussion before. In fact, Mr. Visitor has raised it in other cases. I've dealt with him. We have to remember that the treasurer resorting to a foreclosure is the last step. They don't want to do that. It's a lot of trouble for the treasurer to go through the foreclosure process and have to oversee the sale and all that sort of thing, and they try to avoid it. There are provisions in the GPTA where those who are having difficulty paying can set up a payment plan. They can get extensions. They can get relief.
I think maybe the proper response is, Your Honor, I apologize for that language, and I'll not use that language again. Fair enough?
Sure enough.
Okay.
Thank you.
Thank you. Mr. Visser, you have time for rebuttal.
Thank you. Let me first address the inapplicability of Howard. Howard was a federal case under not addressing the state takings clause at all. It explicitly denies any due process considerations and considers only the Fifth Amendment situation. So I think the fact that it has no due process, your site created that it excluded, it wasn't pled at the trial court in the complaint, and therefore is not in consideration. And the fact that it has it does not address the extra protections under the Michigan takings clause. As far as the FGU's involvement with this, I'll just add a little bit to the record. There's a long history. We can look at the state website as to all the elections that have been made by the state treasurers to become the FGUs when the state treasurer could have been the FGU. That's the way the statute was set up. And starting in 2004.
I don't understand. What is the point of this?
That the FGUs, that they have this has been a profit generating scheme. for the-
You know, whether it's profit generating, or loss generating, the question is whether the FGU is following the statute and whether the statute is constitutional. And you said that there's a takings argument and that there's a notice argument. And literally, we just have to figure out whether that was something appropriate for you to raise when after the appeal, there seemed to be a fairly clear order to enter judgment for the FGU, according to Muskegon Treasurer.
My position on that, Your Honor, is if that's what was intended out of the original panel, I've had other decisions that have said that, enter judgment in favor of the treasurer of the FGU. This one did not say that. It's unique in the fact that it did not say that. It said to enter it in accordance with that. I would then further, even if it had huge restrictions to it, such as to you must enter an opinion. I think Cully versus Marshall of the United States Supreme Court afterwards is an intervening case which supersedes that decision, which says you must have a post forfeiture hearing. And now we're hearing that this, by admissions in the brief, that this taking doesn't occur until after July 1. If that's the case, Cully says you have to have a hearing. If that's the case, then I think you have to have a hearing which incorporates the standards of the Michigan's takings clause into it as well. So I think even if it's the original decision is viewed to be very, very restrictive and should have said judgment in favor of the treasurer in this particular instance, I believe that Cully versus Marshall is sufficient to go outside that and look at that, because we now have acknowledgements that the forfeiture occurs after that particular, after July 1, and therefore you have to have a hearing.
Okay, thank you.
Thank you, Mr. Visitor.
That case is submitted. Moving on to the ninth matter, docket number 377487, In re Johnson Miners. I believe Mr. Ambrose is here.
Good afternoon, Mr. Ambrose.
Good afternoon. How are you?
Doing well.
All right. It's Ronald Ambrose. I'm appearing on behalf of the mother in this case. It's relatively straightforward type of an appeal. The prosecution in this case has not filed a brief. Not sure if that's a concession of error. I hope it is.
Not a concession, but I will state that it's unhelpful when the prosecutor doesn't file a brief.
So not necessarily knowing their position, it's, the issue is the removal of the children, whether or not there was a substantial risk of harm. And, the judge remarked that this was a close call, and after the proofs were taken and took additional testimony from the worker that got into an area of domestic violence, but it still did not establish a substantial risk of harm under the statute. And
I know it's not necessarily pertinent to this appeal, but do you have any update on, have the children been returned to the mother? Are they still going through the process of reasonable efforts and such?
I believe so. That is what's occurring.
You believe that they've been returned, or?
No,
That
that they
the
have.
process is still going forward?
The process is, because I'm still, I've been in contact with my client.
Okay.
And she's interested in what's
Sure.
the court's going to decide. So it's not a moot point, if that's what you're, I'll rely on my brief.
No, thank
I
you.
appreciate it.
Thank you. We
Appreciate you
appreciate you
coming.
showing up, and we appreciate the brief in this case. It's
Yeah,
been
I
very,
do
it's
try
been
to
very
show
helpful.
up when I can. Even though it's on a limited issue, I feel I owe it to my client.
No, and that you absolutely do, and we do appreciate you when you're able to. So thank you.
All right, thank you.
Thank you, Mr. Ambrose.
Calling the 10th matter, that case is submitted. Moving on to the 10th matter for today, docket number 374858, In re Getson Miners. And Miss Ayler Smith is here on behalf of the appellant, I believe.
Yes, Your Honor, Jordan Ayler Smith on behalf of the appellant mother here. I very much appreciate Your Honors allowing me to appear remotely. In terms of the statutory grounds for termination argument and the best interest arguments, I'm going to be relying on my briefs for those, as I know they're extremely factually intensive, unless Your Honors have any specific questions for me about that. In regards to the advice of rights argument, I do have to alert Your Honors to an inaccuracy in my briefing and in that argument. I made the argument that there was never an advice of rights given either on the record or in writing after the second removal. And in my preparation for this morning, I discovered that there was an advice of rights in the June 22nd, 2023 order after disposition. It was on the very last page and I missed it in my initial review of the record. So I did just want to alert Your Honors to that.
Yes. So thank you for alerting us to that. That is helpful. And so if your client was, forgive me if I mess something up, but I believe the children were removed, then returned, and then removed a second time. And if your client was advised about the appellate rights after that second removal, then, yes, the trial court appears to have missed that on the first removal. But where's the prejudice, given the fact that the children were returned, and then there was a subsequent removal in which I think it's fair to say the trial court did appropriately advise your client of those appellate rights. So where is the prejudice from the fact that it was missed the first time, but not the second time?
I think that in terms of the posture of this specific case, I don't know that there is any prejudice, Your Honor, especially because it was cured on that second removal. I think that in this case, and my apologies, the record is very large, as Your Honors know. I believe mom pled to adjudication and then participated in all of her services during that first removal, and then the children were returned for a significant period of time. So I don't think that I would be able to show prejudice on the part of that first removal, Your Honor, and that's why in my briefing we're mostly focused on that second removal, which, as I've discovered, has now been cured. So I don't believe that I would be able to show prejudice just based on the lack of an advice of rights on that first removal alone.
Okay. Do we have any questions on either the removal appellate rights or statutory grounds or best interests? Okay. Ms. Ayler Smith, we appreciate you appearing for argument, and we especially appreciate you updating us and making it clear that there was a mistake in the brief, and you have corrected that, and the court very, very much appreciates it. And we understand it was a big record and things get missed. So, but thank you.
Thank you, Your Honors.
Okay, that case is submitted. Calling the next matter on our docket number 374515, in re Page Minors. I believe appellee is endorsed.
Good morning, Your Honors. May it please the court. Attorney Jordan Swears appearing for the appellee, the Muskegon County Department of Health and Human Services. It will come as no surprise to the court that we believe the trial court properly found statutory grounds for the termination. I won't belabor the point. And as it relates to the second argument on ineffective assistance of counsel, frankly, I do not believe in either the original brief or the reply brief that the appellant came anywhere near establishing that trial counsel did not meet the objective standard of reasonableness, and even assuming for the sake of argument that they had met that standard, I don't believe there's any evidence that it prejudiced the outcome. Frankly, we had requested oral arguments because the appellant had originally requested them, and they are obviously not here. So I'm happy to answer any questions the court has, but don't really feel the need to.
Sure. No, and we appreciate especially when the petitioner shows up for oral argument. It's not always the case. And we may not have any questions in, the mine run of these cases, but when we do, it's very important that we're able to get those questions answered. And so we very much appreciate you showing up.
Very much.
I know you've been sitting for a while, and hopefully we've entertained you a little bit, but your time here is valuable, even if we don't have questions, because on the off chance we did and someone wasn't here for the petitioner to answer, that can sometimes work against the petitioner's interest. So we appreciate you being here.
Absolutely, Your Honor. And
Okay.
frankly, it is always educational watching counsel, even though I hope I never argue a zoning board issue before the court, just seeing the manner in which things are argued. I also note that I believe every time I've appeared before this court, it has been directly behind Attorney Ayler Smith, and I've frankly made somewhat of a hobby of watching her arguments at the court, and frankly leave with notes on most occasions that
She's a frequent flyer and she's excellent at her job. So
and she is excellently named, if I do say so as well. So we've had some conversation on that point.
there you go. All right. Thank you. That case is submitted. And then I have 3 cases that we're hearing on briefs, and I will call. Docket number 376996 in Ray Wilson Minor. That case is submitted. Docket number 374929 in Ray Turner Trogdon Minors. That case is submitted on the briefs. And lastly, docket number 375278 in Ray Moorhead Minor. That case is also submitted on the briefs. And that completes our case call session for today.